Group members: Puteri Asniti Wardah Tut Dakwah binti Adin, Natalie Yap binti Said Teria, Nur Fatihah binti Zulamran, Cantika Purnama binti Nordin, Aimin Rafidah binti Khairil. What is minority? A minority shareholder is defined as a shareholder who does not exert control over a company or the person who hold the lesser vote in the company. What is majority rule? Majority rule is a fixed principle of company law whereby the majority of the shareholders hold the decision-making power of the company. Majority prevail. The common law position was based on the principle of the majority rule laid down in Foss v. Harbottle. The majority rule stands for the proposition that the decision and choices of the majority will always prevail over those of the minorities. In practice, the greater the amount of shareholding of an individual member, the greater rights and powers occur to that individual member within the company. Foss v. Harbottle. In Foss v. Harbottle case, the two shareholders sued against the promoters and directors of the company, alleging that they had misapplied the company asset and had improperly mortgaged the company property. The court rejected the two shareholders' claim and held that a breach of duty by the directors of the company was a wrong done to the company for which it alone could sue. In other words, the proper plaintiff in the case was the company and not the two individual shareholders.
The legal principles. There are two aspects to the rule in Foss v. Harbottle. First is internal management rule. An individual shareholder or even a group of shareholders forming a minority at a general meeting have no locus standi to bring an action to remedy a wrong done to a company. Second is proper plaintiff rule. Where a wrong is done to the company, it is the proper plaintiff in any legal proceedings which seek to remedy it. The proper plaintiff rule applies whether the wrong to the company is accused by the directors, the controlling members, or outsiders. Effects of legal principles. First, rule become a major obstacle in the way of the minority shareholders. Second, company is unlikely to decide to bring an action against majority complaining of their breach of duty. Third, majority also unlikely to bring an action complaining of an irregularity in internal management.
5 exceptions to the rule in Foss v. Harbottle, which are ultra vires, special majority, fraud on minority, justice, and infringement of personal right. Ultra vires refers not only to acts which were beyond the objects and powers set out in the memorandum, but also to illegal and criminal acts of the company. In Malaysia, the common law position in relation to ultra vires acts of the company has to be reconsidered in the light of Section 20 in bracket 1 of the Act. Special majority. Special majority is where the transaction in question is outside the scope of the AOA and can only authorize by a special resolution to alter the AOA, or for any other reason. It requires a special majority to sanction it. Non-compliance of this requirement by the majority give rise to a right to bring an action. Fraud on minority. Fraud on minority means an abuse of power whereby the majority secures an unfair gain at the expense of the minority. If the majority commits a fraud on the minority and the injured party is the company, the majority shareholders are permitted to bring an action in the name of the company against the majority. Infringement of prisoner's right. Individual members may bring an action to remedy an infringement of their prisoner rights. Such rights may be conferred by the Act, the Companies Article, or a separate contract, for example, Section 65 of the Companies Act.
Types of action in mandatory. Firstly, is possession. It is command by a member to enforce a right to him personally where such right have been abused by an act. For example, opposition action where a shareholder commands action to enforce the term of a contractual obligation with the company. Secondly, representative action. It is common where any individual member's right has been infringed and the infringement affects other member in the company and the appropriate action will be representative action. For example, for this case, it is a member will be sued by the company on behalf of himself and other aggrieved members. Third is derivative action, which means this action means is when the minority members of the shareholder bring an action in the name of the company to correct the wrong done to a company by majority in controlling shareholder.
Now let's talk about statutory protections. Under statutory protections, we have Section 181 and Section 281 Cross 1 Cross 1 Ramen. Section 181 Cross 1 is the section that provides remedy to the members in the situation whereby the affairs of the company are conducted in a manner which is oppressive, discriminatory, prejudicial, or contrary to the interests of the members. Oppressive action can also be clarified as an unfair abuse of powers, burdensome, harsh, and wrongful, or a total opposite from the standard of fair treatment. The wrongful act could be expropriation of corporate assets, diversion of profits, disregard of minorities' rights, and depriving information. If ever the mentioned manner has been conducted, the court may make any order as allowed by Section 181, Clause 2. The court will conclude whether there has been any oppression, disregard, or any wrongful treatment has been done to the shareholders. During the deciding process, it's important to note that it's the effect and the result that matters, and is being focused on, not the intention or the motive of the wrongdoers. Section 281, on the other hand, indicates that the court can order a company to be closed down if based on the court's judgment there is an equitable and reasonable ground to do so. The decision by the court is discretionary. Example of oppression. In this case, the company is run as if it is a sole proprietorship. One of the directors did not do a consultation with the other directors in coming up with a decision for the company. Another example of oppression is the recast iron product, whereby a company is not declaring dividends continuously although there are profits made in the company. However, the protection from Section 181 is only provided to the shareholders and the debenture holders. If a person has bought a share from the company from another individual, and that his or her name is not on the registered list of members, he then cannot be considered as registered shareholders and thus can seek protection from Section 181. To conclude, the resolution of the majority shareholders prevails over the resolution adopted by the minorities. Nevertheless, there are also situations whereby minority rights are protected by statute. Thank you for watching. Bye.